TorahCafe.com.
The topic tonight, and I'm going to be really brief, is when law and religion collide. And I assume that word was chosen in tribute to the personal injury lawyers among you. Because sometimes law and religion collide, and sometimes they intersect fairly gently, and sometimes they nurture each other lovingly, and sometimes they look at each other with a kind of mutual confusion or suspicion, as in, what are you talking about? And we're going to try to clear a lot of this dust away. But one thing I think can be asserted is that the link between a secular society and a strong religious movement is really not in conflict. And I'm going to quote a rabbi of the first century, Rabbi Hanina, who instructed his followers, "Pray for the welfare of the government, since but for the awe thereof, man would swallow each other alive." No Tea Party member, he. Perhaps a Glazel Tea Party member, I don't know. But this is 1,800 years before James Madison said, "If men were angels, no government would be necessary." And it's really a strong recognition that without a strong civil society, the idea of a flourishing free religions is really quite difficult to comprehend. But when you try to untangle the contradictions and connections between religion and government, it really makes the Gordian knot child's play. Just consider, the Constitution's First Amendment, and by interpretation or incorporation the 14th, say that the government can establish a religion and can prohibit the free exercise of religion. But neither of those things are absolute. I mean, apart from the obvious, no human sacrifice, thank you, Mormons had to abandon polygamy. Parents whose faith forbids blood transfusions often lose temporary custody of that child if a court decides a child's life is at stake. Their free exercise ends where that child's life begins sometimes. As far as establishing religion, if not a specific one, the same U.S. Supreme Court that has said no voluntary prayer in school, no voluntary Bible reading, opens every one of its sessions with a prayer that God save this honorable court. The late Justice Douglas, whose wall of separation was as high as any of the justices who ever lived, wrote once, "Our institutions presuppose a supreme being." If an atheist were to hire one of you to argue against a religion in the public square and paid you in cash, the money would say, "In God we trust." So these trying to figure out a Venn diagram of where religion and the law intersect and where they don't is something that is tricky, and it's why I'm really glad we have the panel we do. Now, to introduce each of the subjects, I guess in tribute to my 30 years in television, we are going to use video. And while this first piece of video may not look like it comes from a religious scholar, you'll see why I think Rabbi Lubin chose it. So in the words of Rabbi Warner Wolf, let's go to the videotape.
You co-sponsored a bill requiring the display of the Ten Commandments in the House of Representatives and the Senate. Mm-hmm. Why was that important to you?
Well, the Ten Commandments is not a bad thing for people to understand and to respect.
I'm with you.
Where better place could you have something like that than in a judicial building or in a courthouse?
That is a good question. Can you think of any better building to put the Ten Commandments in than in a public building?
No. I think if we were totally without them, we may lose a sense of our direction.
What are the Ten Commandments?
What are all of them? You want me to name them all?
Yeah, please.
Don't murder. Don't lie. Don't steal. I can't name them all.
Congressman, thank you for taking time away from keeping the Sabbath day holy and talking.
He left out always wear clean underwear if you get hit by a bus also, I noticed. But the reason why this is so relevant is that the display of religious symbols on public land is a constant argument before the courts. Just to show you how complex it is. On the same day in 2005, the United States Supreme Court said the Ten Commandments could be displayed on the state capitol grounds in Texas because it was of a historical nature, but could not be displayed in the courthouses of Kentucky because it was religious in nature. So, Judge Wilson, I don't know, are the Ten Commandments on display in your courtroom?
No.
If you're confronted with that kind of an issue, and one side says, well, it's really just about the historical development of our country or the law, and another person says, but it uses the language of religion, how would you as a judge try to untangle that Gordian knot? What's your approach?
Research, research, research. I mean, the difference perhaps for me sitting here as a judicial officer is obviously my decision is one based in law. And there are varying decisions that have come out, and the standards that have been set, I would have to research what is being requested exactly, what religious display is being requested, if it's Ten Commandments or some other kind of display, where it is, and make a legal determination. And it's not one I would give you today because I don't know if that question would come before me.
Professor Gillers, is there any kind of coherent line that the courts have drawn to say, yes, here, this piece of this artifact, this language is okay for the public square, this isn't? Is there any bright line or even blurred line that you can think of that helps us?
No.
We're a very informed panel, aren't we?
And they say professors are wordy. Would you like to explicate that a little? How do they? Is it all strictly case by case?
Well, they do research, a very judicious answer. There is a historical dimension to the Ten Commandments, of course, and studying them is not necessarily a religious function. I think in Kentucky, it was the context made it clear that the purpose was religious. Same thing in Georgia or in Alabama. But in Texas, it was going to be alongside other historical artifacts and documents, and it was one of many, and that denuded it of its religiosity. And
Okay.
that's the difference.
Well, fine, but on Broadway and 72nd Street, an area where there are significant members of the Hebraic community, every Hanukkah, a huge menorah is displayed right in front of the kiosk. It's on public land, it's a public park, and every day another bulb is lit. Now, this is not a tribute to energy conservation. This is a clearly religious symbol. And yet, maybe it's because nobody bothered, but it would seem to me that there's no way you can argue that's a historical tribute. That's a religious symbol on public land.
This is Broadway and 72nd Street.
Yeah.
I thought that was always there to let you know where Fairway was.
That's a different religious institution. But it does strike me that, we've talked about this often as this is a product of, say, a deeply evangelical community insisting that the cross be displayed, and yet here is a clearly Jewish symbol on public land, and it shows up every Hanukkah.
I think the considerations would be who pays for it, right? So it can't be public money. And second, can persons with other religious beliefs use that space within the constraints of time, place, and manner to exhibit their own religious symbols? If all of that is true, then all that the state is providing for a brief period of time is some square footage of property. The state is not endorsing one religion over another, and it's not supplementing the cost or providing the expense. And so telling the state that, or letting the state accept that, it simply defers to the religious choices made by others, not by the state.
Okay. Rabbi Yaffe, there's another area that, particularly around the time of holidays, both Jewish and Christian, stir a lot of controversy, and that's when a community makes accommodations for a religious institution in terms of parking. It says, okay, on this day we're going to suspend the parking laws. It is in that sense accommodating a religious institution, a synagogue, a church. Is there any issue here that suggests that the state is overreaching when it accommodates a religious institution like that?
Well, let me
Use the mic. I just want
Is
to
it on? Yeah. I would first of all say that my formal title or even my background is not the constitutional lawyer here. I think we have several. That being said, to me, and this is terribly important, this is a country which says there shall be no establishment of one religion favoring another. You already borrowed my favorite quote about all the institutions of this great nation presuppose the existence of a supreme being, and it was always about freedom of religion. There is no state worship of secularism such as you have in France, and they're trying to impose upon various minority religious communities in Quebec. Somehow large crosses are okay, as you know, because they're historical, but everyone else's religious symbols are not okay. We don't have that tradition in this country. We have a tradition of respecting religion but establishing no one over the other. So if I accommodate the fact that throngs of people are going to be attending whatever their house of worship is, this is something which is appropriate. It's only a problem if I allow one religion parking help and don't allow the other. More importantly, I think there is a sense that each individual, each group of people, creating strong religious communities is something that is on the whole healthy for the body politic. And I think a great deal, for example, of our tax code that gives enormous, frankly, rabbis and religious institutions get better tax breaks in this country than they do in Israel. And part of that is because there is a deep sense within the entire fabric of this nation that strong religious communities, as long as they respect each other and do not seek to impose their will upon the nation, are a very healthy thing for this country.
So let me throw you a slightly or maybe substantially tougher example, because you can argue, look, the state accommodates a church or a synagogue, it also accommodates a high school football game, it accommodates a rock concert, it accommodates all kinds of things. In deeply religious neighborhoods in Brooklyn, on public transportation, the stories are that men are insisting that women sit segregated. Now that's deeply installed tradition in this community, but on public buses, well, I suppose I should start with the judge. Would that strike you as possibly defensible? To segregate by sex because that's what a religious, a powerful and influential and majority, perhaps, religious group in that neighborhood believes is necessary? Would you sustain that?
I'm troubled by it. And I guess any of the questions that you ask me that are really legal questions, and I'm sorry if it sounds like I'm punting on it, but with the chance that it can come to me, I'm not going to give you a definitive answer of what I would do with it. But I think I can highlight some of the problems. I mean, going back to, if I can for a moment, stepping back to the question you asked about parking accommodations and things of that nature, I think there you also have something that's defensible because we have a public safety overlay there. So what you are is you're not just accommodating a religion, but understanding that people who are going to exercise their religion for safety reasons need to have certain, perhaps, police lines drawn, areas for parking. And that's why I think it was brought up a high school game or anything. That's a public safety issue. Now we're getting to an issue instead where you're talking about should we segregate on public transportation by sex?
This isn't a law. This is just what the custom of the community is. Woman gets on the bus and the men say, go to the back.
Well, that's a personal choice. I don't think anybody can force them to do it. That's the way I would see it.
Okay.
And so if what you're saying, as long as it's not that they're asking the transportation company to accommodate it and telling the bus driver or the train operator, the subway operator, you have to have them go that way, I don't think they can do that. But if voluntarily the community itself, both sexes, respect them and want to do it, that's up to them.
You okay with that, Professor Gillers?
I'm totally okay with that. It's we should not officially deny a voluntary choice. It may not be our choice, but as long as the state doesn't impose an obligation to segregate, it's fine.
I want to come back to the tax exemption issue. There are folks, particularly in the so-called televangelical community, where the tax-exempt institutions, where the ministers live very well. They live in mansions donated by contributors. They fly on private jets. There was a comedian who once, imitating Billy Graham, said, "God thinks I look better in $4,000 suits." My question is, could you imagine a situation where the Internal Revenue Service said to a religious institution, the level of the standard of living that you are engaged in is so high that it doesn't deserve tax exemption as a religious group? Or is the fact that the person is a religious cleric, a rabbi, a minister, a priest, whatever, mean that the state has nothing to say about the level at which he or she is living?
Well, as a rabbi bereft of all private jets, let me make the point that this is, if you'll forgive me, perhaps a bit of a red herring, because
herring is fine,
right? Because as someone, as anyone who deals with these exemptions, as I do when I file, know, your salary is taxable like any other salary. Benefits in kind that are not directly used. If I use the synagogue private jet, not that I know any synagogues that have such, for private use, that's an income benefit, and there are various tax laws applying to it. I'm sure there's a lot of tax attorneys in this room. What you're discussing is the money that comes in to the religious institution and that the religious institution is using. That's a separate question. So I don't know, if the religious institution wants to pay a very large salary to its leader, and that leader will turn around and pay proper taxes on that salary. Rabbi salaries, reverend salaries are taxed. So I'm not sure I quite understand what the issue is. If you are arguing about the particular parsonage exemption, where, in theory, a very beautiful mansion.
Not so much if you've seen some of these places, it's not so much theory.
Very beautiful. Look, you can build the biggest, most beautiful synagogue in the world. That should indeed be exempt. If you argue that the luxury and the amount of money spent on the parsonage goes beyond what is reasonable, and you want to start taxing parsonage beyond, say, whatever is more than 160% of the average price of a house, because you know what? I can tell you that I have a sister and brother-in-law who are Chabad rabbis to a community in the Bay Area. They live with all their children in this tiny 3-bedroom house, and that house probably costs as much as 4 houses in Hartford and 2 houses in Boston and so on. Are you to tell them they have to live in a studio with all their children? But once you get what is the appropriate number and you want to make a law that says at a certain point of luxury we're going to start taxing you on that, I have no trouble with it. I do have trouble with any attempt to sort of negate this appreciation of the role of religion as a positive force in society, which drove these laws.
So let's pick up on that, Professor Gillers. There's an argument, it goes back some decades. I know within the civil liberties community, a couple of people I know who were in the American Civil Liberties Union got very upset with what they regarded as a move towards zealotry. They said, we've ceased to become an organization defending the First Amendment, and we seem to be an organization that wants no accommodation made to religion at all. And it came out, there was a book, The Naked Public Square, that argued this. From your understanding of I may be asking you original intent questions here, but from your understanding of what the framers had in mind, did they have in mind a government that kept religion at arm's length, that nurtured and encouraged religion, provided it wasn't an establishment? And where do you think, I realize that I'm asking you perhaps too simplistic a question, but is there some kind of clue within the Constitution that tells us how much religion is to be accommodated, how much it isn't?
Well, I think there are three categories. Hostility, which is not required or sensible as a matter of public policy. Reasonable accommodation, where the government is not endorsing any particular view of a religion. And economic support, including through tax code benefits, which at some point should not be allowed. Because frankly, we know, don't we know, that if we begin to tolerate indirect financial support to a religion, whether through the tax code or somewhere else, that some groups will benefit more than others, and those groups that benefit more than others are not going to be us, right? I mean, we're a minority. And consequently, the effect of the financial assistance, once you cross a line, becomes establishment or endorsement or encouragement that should be unacceptable.
Maybe that leads to a much more fundamental question, which has been asked, and I mean, the courts have never answered it in the way that the proponents have wanted, but what is the government doing exempting religions from all taxation? Why isn't that a kind of in-kind contribution that the First Amendment forbids?
One could make a good argument that religion should not be exempt from all taxation because it is a supplement indirectly, and anyone who sets up a equivalent to a religious organization that doesn't have a deity, an ethical culture arrangement, may not enjoy that benefit, may legitimately have a grievance if they do not.
Well, take that on, Rabbi Yaffe. I mean, I'm establishing the Institute for Philosophical Examination. It's secular. It asks fundamental questions about justice and fairness. Maybe it has a breakfast program and feeds the poor, but it is in no sense linked to anything we would look at as religious. Why? Now, should I be treated differently than a religious institution?
First of all, I'm a drop puzzled because my understanding is there's a broad range of tax exemptions for many types of nonprofits
Yes.
and charitable institutions. I don't think religion should be singled out to be worse off. That being said, if this society somehow is missing benefits that are given religious institutions that do the same thing, so give them the benefits. From a Judaic or practical perspective as an American citizen, I have no trouble with that.
I want to shift to one other area before we move. This actually is in the material you got. It's a sort of fascinating case, I think. A synagogue wants to sell its property. It just doesn't have enough people coming. They sell to a non-religious entity. Parishioners, congregants say, you can't do that because our law forbids you selling this property to non-Jews. And this decision should be made by a religious tribunal. The courts have held no, secular law should apply. And, we're seeing this you can see how this comes up, not just in Jewish law, but people who are saying, well, we're going to subject these individuals to Sharia law if they're Muslim. How much accommodation, if any, does the secular court system of the United States say, okay, here are disputes that will be resolved religiously, whether it's a divorce, child custody, property. Here is one where the secular institutions prevail.
By the way, in that case, it actually was being sold to a religious group. It was a group of Indian descent.
Thank you.
But it was just that they said it was not a Jewish group, so that they were opposing it. Where they got them from, I don't know anyway, that it indicated that that was against their bylaws or rules or regulations. But I know in that case, which came out of Perth Amboy, essentially the judge indicated, of course, that there was an adjudication that could be made of secular questions, and that he would not invade the province of religious issues, which is what the appellate division upheld. I think it was right. It's a delicate balance that somehow has to be struck as to whether you are going to be in some way deciding religious issues. It doesn't appear to that have been to the case. It was the sale of property. They had a group that governed the synagogue that made a decision because essentially the synagogue, Perth Amboy's lost its Jews. It's not the community it once was. And they couldn't sustain themselves. They tried to find someone who would come in of Jewish persuasion. They couldn't. And ultimately, they've got a building that can't function. And they made an economic decision. And it was a decision to sell. It was a purchase decision. And I don't think there was anything in there that was of a religious nature, even though I think the dissenter tried to argue, certainly before the Jewish tribunal, that it did involve a Jewish issue. These are case-by-case determinations as to whether you're dealing with a secular issue or a religious issue. So there's no across-the-board way you can decide these cases. You decide each case as it comes on its facts.
Rabbi Yaffe, is this a case where the word collide does have relevance, where, in other words, these folks are saying, look, this should be governed by Jewish law and by a Jewish tribunal, and the other side is saying, no, it's not. It has to be governed by secular law. I mean, is there a conflict here?
It is entirely possible, not having read everything carefully, that there is a conflict here. But nevertheless, the fact that I believe with complete faith that the Jewish law should govern this case doesn't mean that a judge, even a very devout Jewish judge, might not follow the law, should follow the law of New Jersey and United States on this issue. About this, I'll quote Ethics of Our Fathers again, that the person who sees the future is the wisest person of all, that you create a synagogue constitution that clearly makes a legal agreement to subject future disputes to abating. And there are ways of creating such a covenant that would have solved this problem in the first place. But I really have nothing to say as to how a New Jersey judge should educate.
But that's a fascinating point. What you're saying is, so use the secular law to guarantee that the religious law prevails. Yeah?
Because you have a lot of... One thing that Jewish law and American law share is that almost anything in the realm of monetary and civil matters can be adjusted by contract to which all parties agree.
But hang on one second. Because there's another issue floating around here, and that is we know you cannot have a restrictive covenant based on race or ethnicity or religion. So how can we do it here? Right? We know you can't say these properties cannot be sold to African Americans. Aren't we saying functionally the same thing? Only persons of a particular religion may buy this property.
I think what he was really trying to say is that that kind of dispute as to a sale or determination should go to the Jewish courts, deciding where it goes. Can you put into an agreement that will bind you where your relief will be sought? Can it only be sought in the Jewish tribunal, or can you go to a court of law? I think that's what you were suggesting, as opposed to something that might be a restrictive covenant, what your jurisdiction would be.
Okay, well, that's just like arbitration then, right?
Right.
So, okay.
It's like a contract.
Right. But the overhang of a limitation based on religious affiliation or ethnicity, it can't be used to escape the prohibition, it seems to me, against allowing race and other protected categories to be used as a way of preventing alienation of the property.
By the way, does this come up in, I'm thinking of the area of marital law, maybe because my daughter is a lawyer specializing in marital law. But suppose a husband and wife agree that if they are going to separate, if they're going to divorce, it's going to be governed by a religious tribunal of whatever religion they're in, and that subsequently, let's say, the wife says, I'm the victim of spousal abuse here, and I don't want to go to this religious tribunal because this religious tribunal is going to say I'm supposed to be subservient to my husband in all things and just grin and bear it. Can a couple agree to supplement, to basically ignore secular law and only be governed by religious law? If the woman comes into a courtroom and says, I may have signed that, but I mean, I'm being abused now. This man is mistreating me, and the man says, we're going to a religious tribunal.
Well, certainly there are cases where a party has been forced to go to a bet-in if that's what was agreed to. I think the kind of circumstance that you're talking about is something that could be an extreme one where someone says, I essentially cannot get relief. And in that circumstance, could you argue, similar to what we might under the law, whether you have something that's fraud or whatever involved, where exceptions can be made to the law, to the contract. I think arguments could be made. How they come out by a state court, I don't know. That's who decides these issues, not a federal court.
Oh, okay.
That's where divorce goes. But I think that there certainly could be an attempt to be made that, look, I am in danger. I face physical danger by staying in this situation. But I know that this Jewish court will not save me from that physical danger. I think we can recognize that that might be something that would carry the day to say we have to grant some relief.
Before I ask Rabbi Yaffe, the case we were talking about, the sale of a property, is on page 7 of your materials if you want to take a quick look or study it. It won't be on the final. Rabbi Yaffe, do you want to weigh in on this?
I want to weigh in from the perspective of Jewish law. When you're dealing with actual cases.
We need you to just come a little closer to the mic.
Can you hear me now? Is that better? So when you're dealing with actual cases of matters such as spousal abuse or child abuse and so on and so forth, there's a very important point. We have a primary obligation to protect people's lives, the integrity of their bodies, and so on. Indeed, if there's a suspicion of sexual abuse, the fact is that Jewish law treats sexual abuse the same as it does murder. In other words, the same steps I can take to stop someone from committing a murder, including deadly force, I can take to stop someone from committing a sexual assault. That being said, it's quite clear to me, and I have talked to very esteemed heads of Beit Dins, of rabbinic courts, who've made it clear to me the moment we're dealing with something that isn't about a question of a division of property or how the children should be educated Jewishly and so on, but it's a question of actual danger to someone's life, limb, personal integrity, emotional well-being. So at that point, the rabbinic courts have no power of enforcement in this country. We have no power to make someone stop doing something because that power is not allowed under our system. So at that moment, because the first obligation is to save the oppressed from the hands of the oppressor, miyadoshko, at that point, the Jewish courts need to immediately tell the party concerned, the victim concerned, to immediately go to the secular courts, the authorities, the police, and so on and so forth. As far as an agreement, and by the way, when it comes to child custody, I think everyone here in this room knows that in all 50 states now the best interests of the child is the predominant concept. So any religious agreement that is not in the best interests of the child, as the court understands, will be negated by the court.
It's a perfect place to switch, because what you've articulated here, I think, with real clarity, is in this case, it's very clear that the secular law is going to govern in situations that there is no way that a religious court or religious law can override the commands of secular law when it comes to the issues you've talked about. At least not in Jewish law.
Let me make it clear. I'm not saying, make a very important point, that Judaism does not believe in the division between, religious law and monnet and civil law and so on. There's no God and Caesar dichotomy in Judaism.
Well, we're going to turn to that on the next
However, what is very clear is that where there's an overriding obligation, such as the protection of an innocent and abused party, at that point we say that comes first, and we do whatever we can to do that. It so happens in the United States of America, the only way to do that is to hand it over to the civil authority.
I think a very uncomfortable story that appeared in the New York papers just last week. And I will read this to you. The brave Orthodox Jewish teen whose testimony helped convict a prominent Brooklyn counselor who had sexually abused her was driven out of her own synagogue on Rosh Hashanah last week. The married 18-year-old victim was in the Williamsburg synagogue where her family has prayed for the past decade when a man yelled, "Moser, out of the shul," the woman's husband told the Post. The word Moser refers to a Jew who informs on other Jews to secular authorities. They stopped the parade until she left, said her husband. Some women tried telling my wife to stay and not leave, but my wife ended up leaving. She felt horrible and mistreated. What this sets up is the question of people who believe that their faith teaches them that they must not inform on a fellow member of their faith. Now, again, I think this is maybe a simple place to start. I want to keep with the judge for a minute. I assume that anyone who was subpoenaed, brought in to be a prospective juror who testified, I can't on voir dire, when you're examining them, I cannot inform, I cannot judge a member of my own faith. That person's off the jury, right?
Well, it's going to be a judge, not informed, because if they're a juror, they're not informing, it's only sitting in judgment, they'll be rendering a verdict. And I've had, and actually it's came up last week. I had someone who claimed and brought me an excerpt from one of the Christian scriptures that she said supported the fact that she couldn't do so, and I've had an Orthodox Jew tell me the same. The problem for me is in the first instance, and it's a difficult question, which is whether it's an honestly held belief, or is it someone who's looking to get out of jury duty? Because the woman who came with me came with a nice little typewritten sheet, giving me this proverb that she said, and that was the first time I've ever had anyone do that in the Christian religion. But that's been the dilemma for me when I have a voir dire, and if I call them to sidebar, which is when I would investigate this kind of inquiry, not out in public court. I'll bring the attorneys and the juror to sidebar. How far I can or should go to determine whether it's an honestly held belief.
So let me, Rabbi Yaffe, twist this case just a little bit and not talk about a prospective juror, but a witness. And the witness comes into court, because she's been subpoenaed, he's been subpoenaed, and says, I saw what happened, but my religious faith does not permit me to inform against a co-religionist. What's a secular court to do? What does Jewish law tell us about that? I mean, is it in fact a plausible scenario that someone would come into court and said, I know what happened, but my faith says I can't inform on it?
So if you want to know what a secular court is to do, you have to ask the judge or the professor. That being said, I should really give a very, very brief overview of what this law actually is.
Please.
So,
And I want to know, thank you.
so first of all, as you know, two Jews, three opinions. I am going to go with not just my understanding of the law, but what I have heard and studied from the works of, for lack of a better word, though I hate labels, mainstream Orthodox halachic decisors, including some Hasidic ones, by the way. I'm very close to several people who sit on rabbinical courts that have many hundreds of cases a year. So let me make a very important point, that it is possible that there are certain kinds of cases where it might be prohibited by Jewish law for someone to inform against a fellow Jew. It often has to do with cases where you are already indicted for something and you are offered a substantially reduced sentence or immunity for speaking about what other people have done. There may be a case where you feel that the individual was justified according to Jewish law in doing what they did. There are various details here. In those cases, it may be true that there's a collision. It may be true that, like Thoreau, who didn't want to pay the poll tax, I should have to go to jail and accept upon myself the judgment of the court because I do not want to transgress my religion. And the court, the American court, is doing what the American court needs to do. So sometimes civil disobedience is necessary. San Francisco sought to outlaw circumcision. If, God forbid, I don't think it would ever pass First Amendment muster, but God forbid that were to happen, as Jews, all 6 million of us would be obliged to engage in civil disobedience literally literally put our lives on the line to circumcise our children, as was the case with many in the Soviet Union, and so on and so forth. Jews circumcised their children during the Greek oppression that led up to Hanukkah, even though it was a death penalty matter. That's a separate issue. That I don't think will ever happen in this country. That being said, the places where one could not testify are probably very limited. Let me begin by saying,
I'm taking notes.
let me begin by saying that first of all, where the only way to restore stolen, dishonestly gotten money is through the secular courts, and you're asked to testify, so you should, according to Jewish law, consult with a rabbi. But any rabbi worth his salt, knowing that the only way to save the money, to save the business, to save the person is to use the power of the secular courts, that rabbi ought to, and if he knows anything does, give formal permission to go to the secular court to testify in the secular court. Reb Moshe Feinstein, the preeminent authority in Jewish law in this century, made it quite clear, for example, that a IRS agent is allowed to investigate and seek testimony and so on to convict a fellow Jew of tax evasion, because paying your taxes is under Jewish law an obligation in Jewish law. When it comes to matter of taxes and keeping the commercial codes and indeed all monetary and civil law, Dina de Malchuta Dina, the law of the land is the law of the land is the Jewish law. Since the Beit Din isn't going to get the man to pay his taxes, this agent and anyone he needs to subpoena could, and according to Moshe Feinstein, ought to testify to make sure that the law is upheld and Jews pay their taxes.
Criminal cases.
Now, last of all, the case that you cited, the abuse case. Again, let me just mention something, and it's going to be uncomfortable. It's uncomfortable for me because I don't believe it. And it's uncomfortable, I think, for everyone in this room. But there is a difference in that Williamsburg case between people saying, as horrible as it is, and I believe the person who went ahead and testified against him. Nevertheless, if someone says, look, I simply don't believe this person, and I believe this person fabricated these charges, and I believe this person is innocent, that's one thing, though it doesn't justify the behavior you mentioned from the newspaper. But that being said, we ought to realize that abuse can happen anywhere. We ought to realize that it's a problem. And you'll forgive me for going on, but let me make the point again that all the rabbis I have dealt with have made it quite clear that in cases of potential sexual abuse of minors, that because the court has no power of enforcement and no power of prevention, you pick up the phone and you call the police. That is what you do, and that is what many, many rabbinical courts have ruled. And the reason is because protecting someone from sexual abuse is the legal equivalent of protecting someone from murder, and you do whatever you have to do.
I'm going quite deliberately, for purposes of time and non-confusion, to put aside what I think would otherwise be a fairly potent question, which if how you describe this is what the Jewish law is, let me be uncomfortable. How come so many people in this community don't seem to understand it? You know, the intimidation against this family, ripping down the kosher sign in the girl's parents' restaurant and stuff, the constant attempts at either bribing or intimidating witnesses does not seem to suggest that people in this community have the grasp of Jewish law that you have just described. The problem with that is it will take us into an area that we'd probably be here till midnight. So I want to turn I just needed to make that point, but I wanted to turn to you and ask a broader question. Are there areas where, as to your, now I'm going to sound like the lawyer I never have been, to your knowledge, are there cases in which a court will permit for religious reasons non-testimony or behavior that, were there not a religious ground for it, they would not? Let me give you an analogy.
Too many knots in that.
What I mean is this. It used to be that the only way you could claim to be a conscientious objector in the United States was to profess belief in a supreme being. The Supreme Court undid that. But for centuries, if you didn't believe in God, you couldn't be a conscientious objector. Is there any vestige of that kind of distinction in our courts where they'll say, okay, you're making a religious argument which has more weight than if you just made a secular argument in the same way?
That's a hard question to answer, but is there something you're thinking of in particular?
I'm asking whether or not, for instance, the court will exempt somebody. Well, let's take I can't serve on this jury because we're coming out of the high holy days, and I've got to be in synagogue for, for Rosh Hashanah, for Yom Kippur, for Simchas Torah, for Sukkot, for all of that.
Okay, well, I see three categories. The one you mentioned before about the person who said, I can't be sworn, even though I'm the only eyewitness to this crime because the defendant is a co-religionist, that person goes to jail. That's not an acceptable response. It's civil disobedience. They go to jail until the case is over. The person on the jury who's asked to be excused because of the coming high holy days can be excused. I mean, there are other people who can be on the jury. There's no upset in the administration of justice.
But here's what there is, and it goes back to the first.
Well, let me just finish. Because there's another dimension which friends have talked to me about, and that is, what about the lawyer whose case is set down for trial, a 3-week trial, a week before Rosh Hashanah, right? And the judge says, this is a civil courtroom. This is not a religious courtroom. This is my calendar, and this is what we're doing. And if you can't try it, get someone else. But the case is going to trial September 10th. And that is, no, we may wish the judge not to do that, but he or she certainly can do it.
Here's the other
I
example.
don't think that happens.
Oh, yes, it happens.
Perhaps, okay,
Oh,
not
yes.
in my court.
It
and
happens. It may not happen. It may not happen in New Jersey or New York City,
Okay.
but it happens.
Okay.
Well, it may be in other states, but I mean, frankly, in fact, I was talking to one of my colleagues who's not Jewish, and I mentioned, because we were talking about setting up some meeting, and I said, we can't do it that day. It's Rosh Hashanah. I won't be here. Good, you told me. I have to put that in my calendar and make sure I don't have any lawyers come in that day.
But here's.
But, I mean, I think people respect those kinds of holidays. I don't think that's the issue.
But here's the question. I mean, actually, you've given me an example that I was too clumsy to figure out in the first place, which is, suppose I say, look, I can't be on this case. It's a 3-week trial. I'm talking about a juror now, not a lawyer. The most important business judgments and incidents of my entire life are coming up in the next 3 weeks. And the judge says, you know what? I mean, we and certainly in the days when I remember New York years ago, there was a real shortage of jurors. Got a lot more crime. The judge says, you're going to have to make an accommodation. If a judge is going to accommodate somebody's religious needs as opposed to business needs, isn't that a case where they're favoring religion in a way that might not be constitutional?
But it would be all religions. It's not one over another.
No, I know. But when the Supreme Court banned prayer in school, those were non-denominational prayers. And the whole argument was it didn't matter that it wasn't one religion. It was for favoring the idea of religion. I'm asking the question, can a court say, okay, you're excused on religious grounds, juror 2, you're not excused because you want to leave for maybe legitimate but non-religious grounds?
I don't think it's a fair example and talking in absolutes, because I don't think that's the way it occurs. It may be more akin, if you're talking about a religious reason, to I'll excuse someone. The first thing I'll say is, maybe not everyone would do this, does anyone have a prepaid vacation or a medical procedure that would take place during this trial? Those I'll excuse. They'll be called another time. It's not a problem. That is sort of like the religious excuse, which is, this is something I can't change. I didn't schedule this. This is when the holiday falls, and I have to observe it. The business excuse is also not absolute. I will listen to the reason. For instance, if I've got someone who is a sole breadwinner and will not get paid if they're on jury duty for three weeks, because their employer doesn't pay them, I will excuse someone from a 3-week trial. That is a burden, and it's a financial burden. We make those case-by-case determinations. If someone tells me, I've got an international meeting that was scheduled 6 months ago that I must attend because I am whatever the president, I can't change this because people are coming from 7 countries, I give it. So, you can't say it's an absolute just because it's a business reason. We consider those.
Okay, so your point is, look, whatever the argument is, secular or religious, you're going to weigh it.
Right.
Okay. So just there's one more area in this before we turn to the.
But could I ask a question maybe for the rabbi?
Why not?
Okay. And this isn't the one about being a witness, but it's what we talked about already, which is sitting in judgment of someone, a juror. Is there something in Jewish law that does not permit a Jew to render a verdict?
I'm sorry, I have to interject, but anybody who had a Jewish mother knows that Jews are permitted to sit in judgment of other Jews. just.
I'm going to use that.
I beg your pardon, Rabbi. It's your floor.
Right. So the answer has a lot to do with, for example, if we can bring in, there obviously has been discrimination against Jews, but if we can let me bring a stark example, where you're the Jewish juror sitting in a To Kill a Mockingbird kind of trial. You're a Jewish juror sitting in the Deep South in the 1950s, where even though it's not a co-religionist, it's quite clear that you are going to be part, especially in those states that allow a majority, you don't need a unanimous jury, you're going to be a part to a miscarriage of justice. So if you feel that your co-religionist or anyone else is being discriminated against, certainly there is a problem with being part of that jury because you become part of the miscarriage of justice.
Put aside
especially
co-religionists, just anyone sitting in judgment of a defendant.
There certainly is no issue in Jewish law in general to sit on a jury, and there's a special reason for this. And that is that one of the obligations that is placed upon a Jew living in a civil society, in other words, a society that's other than a Jewish law society, is to engage in behavior that creates harmony and peace and eschews hatred between different groups. If you don't take your burden, and you don't carry a burden, and you don't pay your taxes and sit in juries and so on, you're attacking the cohesiveness which Jewish law actually requires. It's this concept called Ava, which is misunderstood as, they're not going to like Jews. That's not what it means. The concept of Ava in Jewish law means that you don't behave in a way that creates dissension, fragmentation, and hatred within the broader community that we are also part of. So I can't see a problem unless, for example, you're in a state that is promiscuous in its giving of death penalties in unjust ways, and you're going to give someone a death penalty. But in the general case, I don't see why not, and frankly, I know many, many highly observant Jews who've sat on juries, and, they've always kicked me off, but I've always gone.
Before we leave this area, for obvious reasons, we're talking about Jewish law, but one of the areas where the flashpoint may be emotionally much higher is in the area of, say, Muslim witnesses and defendants in a post-9/11 climate. What about a case where, for instance, this may seem odd, but maybe it isn't, a witness to a crime is a Muslim woman, the defendant is entitled to face his accuser, the Muslim woman says, I can't show my face, my religion forbids it. And so how am I going to defend myself if I can't see who you are? And there are other interactions between men and women forbidden. You anticipate, or Professor Gillers jump in, that this is going to be an increasing area of difficulty in secular law?
So the Muslim witness does not want to uncover her face. Is that your example?
Yeah, or it may even be a case where the use of a Muslim name may be seen to affect a jury. I mean, there are cases where judges have refused or have withheld the names of certain people because they felt the names themselves could be prejudicial.
Well, those are two different things.
Okay, I know.
Well, you haven't got a choice but to reveal your face. Our system puts a great deal of weight on fact-finding by demeanor. So people have a right to see you. If it's a criminal case, the defendant has a right to confront you, some exceptions for children. And confront means eye to eye, face to face. So the witness will not be allowed to.
The witness will be in the position Rabbi Yaffe described earlier. She may be the one winding up in contempt of court.
Yes.
Could you imagine that? I mean, I don't even imagine, envision yourself in a situation where you would have to send a witness to contempt because her religion forbids her from revealing her face?
I'm thinking about that. I certainly have not encountered it, and I think it would be a troubling situation. Yeah.
When we talk about punishment, there are all kinds of ways to describe different kinds. What's the purpose of it? Is it to rehabilitate? To make that person better? That's what a penitentiary actually means. Penitent, to regret and make yourself better. Is it to deter? I punish you so the rest of you won't do this. Is it retributive? Vengeance. I don't care whether it deters. I don't care whether this person's better. This person has to suffer for what he or she did. Rabbi Yaffe, what does Jewish law, Jewish tradition tell us is the purpose of punishment?
So I should begin by making the point that obviously what Jewish law believes on this matter is not necessarily going to be the basis for American law. That being said, and this is something I haven't had the opportunity to say yet, Judaism argues that there are universal moral principles that flow from the creator of all of humanity that are obligatory upon all of humanity. As Jews, we have an obligation within the context of ways of pleasantness and peace, within the context of participating in the societies we live in, as if it were to advocate for and to push for the adoption of these ideas because we see them as being of absolute and universal benefit. In that regard, if we are to talk about the concept of punishment in Jewish law, there are many components. There is a component of deterrence, there is a component of atonement, and there is a component of making good the damage that you did. What I do want to say, because there's much to be said, what I do want to say is that the most popular form of punishment in the Western world, which is the prison, is extremely problematic from the Jewish point of view, something the Lubavitcher Rebbe has argued many, many times. And quite simply, the premise is as follows, that every human being has a purpose, and that purpose is to contribute and to build and to make the world a better place. If that person does something wrong, if they harm, there are some crimes that are so horrendous that allowing that person to exist is a negation and a discarding of the value of a human life. So maybe the ultimate penalty is sometimes appropriate. But other than that, other than such cases, it would follow that to throw someone in a prison where all as they will do is rot, and they will do nothing to make the lives of those whom they harmed better, they'll do nothing to add to society, they will simply probably learn to be better criminals. This is unconscionable because if a person has the right to live, they have the right to contribute. And therefore, Jewish law, tradition, and philosophy demands of us, everyone in this room and anyone who can, that we think long and hard about incarcerating all the people that we incarcerate in this country and find every other way, unless that person needs to be locked up because we know they're going to go and offend again. But otherwise, we have to find ways to enable them to pay back, to return, to rectify, and to give back to society, maybe with certain limits on their movement. But the idea to throw people away as so much human garbage is unconscionable from the Judaic perspective.
Now, before I turn to the judge, let me give you Richard Pryor's rebuttal. Richard Pryor, the late and brilliant comedian. Richard Pryor made a movie with Gene Wilder. It was set in a prison. And in one of his monologues, he said, you know, I went to this prison. I wanted to meet the brothers. I wanted to rap with the brothers. I wanted to find out about these people. And then he stops and he goes, thank God we have penitentiaries. Because he asked one guy, why did you kill all those people in the house? And the prisoner said, they were there. My point is, when you sentence, we had this conversation before, I want to acknowledge. My sense is there are times when you look down from that bench and see somebody you're sentencing, and you see evil. Pure and simple, you see evil. Am I wrong about this?
You're right. It's rare. It's rare. And we had that discussion before during dinner. I'll have to admit, and I know there's some criminal defense attorneys out here, I tend to be one of the judges probably who tends to go lower in the guidelines than others. I'm not the...
Turn 'em loose, Wolfson, they call you, right?
Not loose, but I really do try to take the criteria seriously of why we're sentencing. But there are circumstances, and I said to you, in fact, because I said, I've never actually feared for my own safety, but I remembered having a defendant in a drug case, and the drug cases are problem cases, and we know, and that's one of the issues right now about our prison sentences, the appropriate sentences, lengthy sentences for those who commit drug crimes. But I had someone who was a repeat offender, but he clearly didn't take seriously what was going on. He thought he could slide by threatening witnesses, and we had tapes of calls from the jail where he said, don't worry, to his wife about that witness, because, we know where his mother lives. There was a fire at a home nearby of someone who ended up being a witness. A child died in the fire. But when I sentenced him, and he did face a mandatory life in that case. This was one under the guidelines. It was the one time where I had no qualms, because as I looked at him, he was essentially laughing at me. He was cold, and you could see it. There was not one bit of remorse, and it was one situation where I guess I just felt, in fact, so much anger at this person for being who he was and not getting it.
I don't want to gainsay what Rabbi Yaffe said. This country incarcerates far more people by percentages than than any other, certainly any other first world country. We're somewhere up there with Saudi Arabia and Iran. But I want to turn to Steve Gillers to revisit then the initial question I asked, but ask it now as a part of American law. Does our law say, no, you can't punish simply for vengeance? You punish to deter, you punish to rehabilitate. Is retributive justice permissible as you understand American law now?
It's not only permissible, but is very often the best reason to punish, because the victims, the community that's been harmed by the criminal conduct legitimately expects a punishment that, quote, meets the crime. So we tell victims, don't get revenge on your own, because we have a system that does that, and it should. And very often it can be the only reason.
The most obviously heated debate about punishment, which Rabbi Yaffe alluded to, is capital punishment. There's a specific question about this, and I'm not sure whether Jewish law informs, but I think it's really fascinating. Toward the end of his career on the Supreme Court, Justice Harry Blackmun said, I will no longer tinker with the machinery of death. And what he meant by that was he felt that capital punishment was so inherently unfair, arbitrary, prone to judgment, that I think what his point was, I will never affirm a death penalty. Justice Scalia made a fascinating argument. He said, if you believe as a judge that capital punishment is wrong, and you are a judge in a jurisdiction that has capital punishment, the only ethical thing you should do is resign. Because you're telling them that you are not going, or at least recuse yourself from every capital punishment case. Because you have just told us you were not going to enforce the law. Now, this may be a clash between, if your religious beliefs, and the Roman Catholic Church, among others, says capital punishment is always wrong. If your religious beliefs, although the Catholics on the Supreme Court don't seem to be taking that overwhelmingly seriously now that I think about that, but if that's what you believe, do you have a moral obligation not to sit on a capital punishment case, or even take yourself off the bench?
It depends. This comes up with prosecutors, elected DAs as well. There used to be a death penalty statute in New York, and there were district attorneys who opposed capital punishment. If you can subordinate your personal belief and enforce the law, whether as a judge or as a prosecutor, then you can. Jurors, we say to jurors who say they're opposed to capital punishment, could you subordinate your opposition and follow my instructions as the judge? And if they say yes, they're not disqualified for cause. So we recognize that that is possible.
You want to weigh in on this at all?
Yes, because as much as the wholesale incarceration is a bad idea, it's interesting to note that even though there exists a death penalty for a whole range of things in the Torah, the fact is the Judaism has always understood that the Torah and its interpretation represent a single, indivisible whole. And the interpretation of the Torah has always, this is not a later development, from day one, created a system that makes it extraordinarily difficult to apply the death penalty. The answer as to why I have all these death penalties is to let you know that the things that you do, even if you think they're victimless crimes, can have a profound negative effect on the entire project of creation as if it were. At the same time, we don't really trust people to go around killing each other wholesale, and therefore we make it extraordinarily difficult to apply the death penalty. As we're told that a court that sentences someone to death once in 70 years is a murderous court. However, there is a profound exception here because, and this was something actually, there was a Connecticut death penalty case about 20 years ago where they were quoting the biblical sources of Connecticut law, and I was asked to help write a brief on the topic. And basically, in Judaic law, there is an exception about this very strict two witnesses cross-examine, impossible to put someone to death rule. And that is, in cases of murder and other such extremely egregious things, but in particular murder, the court is allowed to say, even though we don't have the formulaic two-witness warning the person within 5 seconds of the act, et cetera, basically under Jewish law, you have to have two witnesses who warn the person, don't do this or you're going to get killed, and that individual has to acknowledge, yes, I heard you, I'm going to do it anyways, and he has to shoot the guy right there, and then within 5 seconds. And then he has to be not insane. So the point is that that rule, in a case where either the murder was egregious, what in American post-Furman statutes called aggravating factors, or in cases where we're concerned that murder has not been a problem and now it's beginning to be a problem, Jewish law says the court can take emergency rules as long as it meets a standard that in American jurisprudence you would describe as beyond a reasonable doubt. We can execute the person because a society that allows murder to go unpunished in the strongest way is a society in which the respect for the ultimate value, that of the human life, the person created in God's image, is in danger. And let me say that Jewish courts gave Jewish murderers over to Polish and Austrian and Russian authorities to be executed because of this ruling. And I have numerous cites for this. So Jewish law does approve of a death penalty as long as you don't have a situation where people are being unfairly given the death penalty. And of course, you're all familiar with such examples in this country.
It's interesting. There's a bumper sticker. And what the rabbi has just done is to rebut the bumper sticker. The bumper sticker says, why do we kill people to teach people that killing people is wrong? Well, this argument says that's right. That's why we sometimes kill people, to teach people how egregious it is to kill other people. But I had never thought that that is actually an answer to that. And this, by the way, I think it's an important footnote, what Rabbi Yaffe just said, because this doesn't account for the arbitrariness, the unfairness of capital punishment, the racial disparities, the fact that if you're a rich person with a lawyer, you probably are never going to hang or get the lethal injection. But let me come back now to where we are. As I understand it, Professor Gillers, what the Supreme Court has said is the only crime for which you can now be executed is murder.
So far, that's what it said.
No, I
Right?
mention that because some of the most famous cases of capital punishment were non-murder. The Carol Chessman case in California was a case where this guy took a woman out of Lover's Lane, forced her into what was then considered a horrible sexual act, and was convicted of kidnapping, not murder. I believe I'm right that only murder is now...
Only murder. The Supreme Court has rejected capital punishment in a series of cases in other crimes, but has upheld capital punishment for murder, but not any murder. There has to be individualization. This is Lockett versus Ohio in the sentencing. And there has to be a consideration of aggravating and mitigating factors, and they have to be balanced against each other, and the aggravating factors have to predominate. So you have to take the death-eligible pool and reduce it further by looking at the individual circumstance. You can't have a mandatory capital punishment statute.
By the way, Judge, have you ever had to impose capital punishment?
No.
It's on the federal books.
Yeah, very, very limited. I think there have been a couple that I'm aware of while I've been on the bench, trials,
Right.
but it's so rare.
Would it be fair to say that if you were faced with a death penalty case, this would give you some qualms?
Yes.
Thank you.
Of course.
Yes.
There's another area where religion and punishment play out, and that is whether or not a defendant's religious beliefs or conduct might affect sentencing. A case where somebody is in prison awaiting next, and we're told this person has undergone a religious conversion, is now a deeply religious, you fill in the blank of whatever religion that might be. Would this, you think, be a valid grounds on which to assess how much to punish someone like that? Let's start with the assumption this is sincere.
So under Jewish law, we specifically forbid the court from considering anything that cannot be seen empirically by laws and hard evidence. In other words, God sees the heart, but we only see what the eyes bear. The person's repentance, remorse, religiosity, self-transformation, we cannot deal with that because we are not qualified judges of that. Only God is, and God will do what God wants to do. It's not our business.
Is it your business, Judge? Somebody comes to you before sentencing and you're told, let's take the rabbi's language, there's genuine remorse. This person has tried as hard as he or she could to make restitution. He's doing all kinds of acts of what's called in another religion corporal mercy. But, he's already done the deed. There's all stuff that and you're thinking what on the bench?
Well, let's divide it. Doing good deeds versus getting religion are two different things. I've said a number of times that it's amazing between the time of someone being arrested and either pleading and finally coming in for sentencing, how many get religion? All of a sudden, they come in and they tell me, and I get letters from their pastor and religious leader and relatives, they now go to church all the time, or this is what goes on, and they found religion and believe in God. Okay. That doesn't sway me. But it's all fits into what has this person done if they've been on bail, waiting sentencing. And there are a number of things that they can try and do or have their attorneys suggest to them that they should do before coming in for sentencing. If it's a monetary crime and there's going to be a restitution component, have they already tried to make restitution? If it's a tax offense, have they tried to go back and file their tax returns and pay the taxes before coming in for sentencing?
None of these judgments relate to the piety of the defendant.
That's right.
And if someone came in and said, but this person has now become a deeply religious person and is constantly a church or synagogue or mosque.
That alone means nothing.
Nothing.
Nothing. And from my perspective, other than if it's part of an overall change in this person and how they live their life. But then you have to get into, is it real or is it not?
Well, now let me throw you the other side of this, Steve, because one of the areas that Professor Gillers is like the reigning macha is ethics. So what about a case where a defendant has used his or her religion to help commit the crime. I am thinking, and maybe religion is too strong a word, but certainly his religious background. So I'm thinking here of Bernie Madoff, who bankrupted countless numbers of people, in part by arguing, I'm a trustworthy person, I'm one of you. I believe I think he actually bankrupted the Elie Wiesel Foundation, if my memory is correct. I should know that because I talked to Elie Wiesel about it. In other words, using your religious background to further a crime. Would that be a case where you could argue that the crime was more heinous than it was just an ordinary con man?
Absolutely, and it's part of the larger picture, and that is using the trust that you've improperly earned in a network of people because of X. It could be a religion, it could be a social network, but over time people have come to trust you, and then exploiting that trust, whatever the source of the trust, to victimize those people is certainly a basis for enhancing punishment.
And I think I spoke to you about this before. I mean, I do find troubling, and this occurs in the civil cases as well. We see many Orthodox, or certainly I see many Orthodox, Hasidic Jews come in and profess their piety. As I've said, I can't come tomorrow, it's Tisha B'Av. I can't come next week, I'm going to Israel. I can't come 3 weeks from now because it's this holiday. I got to fast on that day. But at the same time, what do they have before me? They have cheated another individual in business. I cannot tell you how many business disputes I have between Orthodox Jews. And there's clearly one or the others that cheat, or both of them, on what's going on. And it is appalling to me to hear the proclamations of piety when they are unscrupulous in business and they're not living their life, from my perspective, in a pious way. To me, it's extremely troubling.
Rabbi, is there something in Jewish law that makes a special case, special sanctions against people who would misuse their religious faith to do wrong?
There's no question that there are a range of laws which impose much stricter sanction against people who have positions. For example, you're not allowed to break a confidence, but a judge, a member of a rabbinic court who breaks a confidence of various types, time doesn't allow the discussion of it, is disqualified from ever sitting on such a court again. We typically, and certainly we see this with regards to Judaism itself, God judges Moses more strictly for not listening to him and striking the rock instead of speaking to it, because Moses is at the acme of spiritual height. Typically speaking, the more one knows and the more one is seen as pious and the more one is seen as a leader, the stricter we are with them and the less leeway we give them. And the more careful they are told to be with regards to anything that might appear to be improper. That's first of all. Second of all, I have to respond to the judge on two levels. On one level, the definition of someone as a religious Jew, it means that if you're an observant Jew, that means you keep the 4 portions of the Code of Jewish Law. If you'll go to Rabbi Lubin's house, my house, or any house that has a good Jewish library, you will look at the Code of Jewish Law. It has 10 volumes. The 3 fattest volumes, 38%, 40% of the entire work, deal with Archosh and Mishpat. They deal with monetary and interpersonal law. And being a observant Jew means you keep those laws the same as you keep any other law. So just as someone who's extremely honest, but say might not fast on Yom Kippur, I would say that person is not an observant Jew, a completely observant Jew, everyone's somewhat observant, etc., all that. By the same token, someone who might fast on Yom Kippur and pray 3 times a day, but is not careful about being well-behaved and honest in their business, is equally not a religious and observant Jew. That's on one hand. On the other hand, no one's perfect, and we shouldn't assume that, everyone in this room knows of their own internal personal struggles. We just spent a whole day with them on Yom Kippur. And it's also true that the fact that someone is not keeping one law and has fallen morally and religiously short in one area doesn't mean that all their other good deeds have no value. So we have to balance that on both sides.
We're coming to the end. There's one question I'd like a relatively quick response, but it is another one of those that's a hot button, and that is, what religious rights do the incarcerated have? How far does the secular society have to go to accommodate them? And I'm going to ask you to be relatively concise. Does a Muslim entitled to halal? Is a Jew entitled to kosher food?
Yes,
they must supply those?
Yes, they are. It's a question of degree. Can you accommodate the honest religious tradition without compromising the safety and security and the operation of the prison? And very often you can.
I have to. Muslims pray 5 times a day. The prison says that doesn't fit our schedule. We have a rigid schedule of what these prisoners have to do.
That may be true, and that may not be allowed. I just don't know enough about the schedule. But the question is, can you make the reasonable accommodation without seriously compromising the function of the institution? If the answer is yes, then do it.
Yeah, and look, we're not talking about absurdities. I don't think anybody's religion requires prime rib. But I am wondering to what extent, the system seems to have gone a fairly long way to trying to accommodate the religious requirements or needs of the incarcerated.
They do.
And I guess the question then is there, obviously there is a limit, but how do we know when things are going too far?
Well, most of this coming under RLUIPA, the statute, the federal statute, the Religious Land Use and Institutionalized Persons Act. And there's some balancing that's done, but certainly when you talk about, for instance, having kosher meals, that's done. Muslims are, actually what's often happening is they're giving some sort of kosher meal because it's killed in the same way some determinations are made. We've gone so far as, someone who's a Native American that believes in the sweat lodge. There's been some sweat lodge accommodations done in the New Jersey State Prison for them.
Yes.
We've gone pretty far, but it's not limitless.
And I assume that Rastafarians are not permitted to smoke ganja. No, look, it is part of a religious belief. Native Americans, some of them believe peyote is a magical drug that gets them to a spiritually higher place. I don't think they've been accommodated on that one.
And that's where you start getting into the balancing and the functioning of the institution and what makes sense.
Yeah.
So there is some balance that's struck, but certainly there's a great respect for honoring religion in the prison setting. Yeah.
Which actually brings us to where we started in some magnificent Aristotelian way. What business is it of the prison system to accommodate religion? Why is the religious practice of a prisoner put on a higher standard than, let's say somebody who wants to exercise 5 times a day? I'm going to give you the last word on this. Go ahead.
I think the basic premise is that incarcerated Americans are American citizens. They lose some of their rights, but not all of their rights. The right to the free exercise of religion is in the very first amendment to the Bill of Rights. And it's quite clear, as we started this conversation a while ago, that our society justifiably and correctly sees religion as an important positive force. Why would we suggest that a prisoner not have those rights, in as much as we still give them the rights to due process and so on and so forth? Why is the First Amendment different from the other ones?
That's a question for Passover. Why is this amendment different from all of them?
Maybe it isn't.
Maybe it is. We've come to the end of this. I did not know what to expect, frankly, when I was invited here. I have to tell you that both in terms of you, the audience, and your attentiveness in this panel, has, for me, made this a really delightful evening. Thanks for joining us, and thanks to the panel.